DWI is the gift that keeps on giving. Even after you've been convicted and faced the criminal consequences, you could face years of additional license suspension. I'm Clark Dummett with Dummett Fraden, and we're going to discuss all of the driver's license suspensions which you face after a North Carolina DWI conviction. Under North Carolina law, if you're charged with a driving while impaired charge, there are potentially 3 revocations that could hit you. First, there's a civil revocation imposed by a magistrate that will last for 30 days. Second, if you refuse a breath test or a blood test, the Division of Motor Vehicles can impose an administrative revocation of your license. Third, if you're convicted, a judge can impose a criminal revocation. Lastly, in this video, I want to walk you through the dreaded interlock and when that can be imposed and how you deal with it. It's important that you go through each of these with your criminal defense attorney. In discussing the civil revocation in greater detail, it's important to recognize that it's non-criminal in nature and it really doesn't affect your criminal background. This 30-day civil revocation will be imposed by a magistrate if you blow a .08 or greater on a breath test, or if you refuse the breath test. In both of those circumstances, the magistrate is authorized to immediately revoke your license the very night you're charged. So you don't end up with a civil revocation if the officer chooses to draw blood. The reason is there's no result to base this civil revocation on. If, on the other hand, the blood comes back above a .08 3 weeks or 3 months later, they can then kick in the 30-day revocation based upon a blood test result. If you do end up with a blood test and getting a revocation months later, it's important that you turn in your license immediately, because if it's not turned in within 5 days, then your 30-day revocation is extended to a 45-day revocation. After 10 days, you can petition the court to get a limited driving privilege during this 30-day civil revocation. It's not required that you have a lawyer, but you would need to know how to draft all the forms correctly, file the petition, get it served on the DA's office, get it scheduled in front of a judge, and then present all the supporting documentation correctly. In other words, you should get a lawyer. The second type of license revocation that DWIs can cause is an administrative revocation at the Division of Motor Vehicles. This administrative revocation is based upon a legal fiction called the implied consent law. North Carolina recognizes this make-believe legal fiction that you will consent to a breath test if you drive on the roads. It's implied. When you've been arrested and you're down in the breath room, the officer is going to read you your implied consent rights. And if you refuse to take a breath or blood test, you're subject to a 1-year administrative revocation. This is not civil and not criminal. It's an administrative revocation issued by the Division of Motor Vehicles. On the night you're charged, the law enforcement officer or the chemical analyst is going to fill out an affidavit, and they're going to check box 14 on the affidavit and mail that off to the Division of Motor Vehicles. So 3 weeks to 3 months later, you're going to get a letter in the mail saying you've refused a breath test and to turn in your license for an automatic suspension. Be aware that you only have 10 days to apply for a hearing once you've gotten that letter. Also, be very careful if your address is not up to date with the DMV, you may never get that letter and be subject to a 1-year revocation without a hearing. If you miss your window of opportunity for this administrative revocation, you will be subject to a 1-year license revocation. You'll be eligible for limited driving privileges after 6 months, as long as you have the DWI completed and you have completed any alcohol classes. So if you're subject to a 1-year license revocation for refusing a breath test, there are 3 factors we've got to look at. You can't have had a prior refusal revocation in the last 7 years. You have to have the DWI criminal charges fully resolved, and you have to have finished your alcohol classes. Then, only after 6 months of no driving at all can we get you a limited driving privilege. If you're facing a 1-year refusal revocation, it's critical that you get an attorney that knows what they're doing, because these administrative revocations can run for an entire year and they can overlap or run concurrently with a DWI revocation, depending upon how your case is handled. The third form of license revocation is a criminal revocation after a conviction in the courtroom. Under North Carolina law, NCGS 20-17.8 and 20-19, you'll be revoked for anywhere from 1 year to permanently revoked, depending upon your prior criminal record and any driving while impaired revocations which you have on your license. In general, on a first offense, you're facing a 1-year revocation, and you should get limited driving privileges during that, depending upon a lot of factors. If you have a prior DWI conviction within the last 3 years before this charge, you're facing a 4-year revocation of your license. You may be able to get a conditional restoration hearing at the DMV after 2 years, but you're going to have to win that to get your license back early. If you've got 2 priors within the last 7 years, you roll to permanently revoked. If you're permanently revoked, it doesn't really mean forever. Permanently is a status at the Division of Motor Vehicles, which means you're going to remain revoked until you go to a conditional restoration hearing and get your license restored. If this is your first conviction in 7 years, then you should be entitled to a limited driving privilege. The hours can vary greatly. There are 2 different types of limited driving privilege hours. There's standard hours, which are 6 in the morning to 8 at night, Monday through Friday. And then there are non-standard hours, which are after 8 o'clock and on weekends. If you get standard hours, you can use them for work driving as well as maintenance of household. So you can go to the grocery, go to the pharmacy, you can do things that you have to do to maintain your household during standard hours. If you need to drive during non-standard hours, we've got to get the documentation of where you work and the hours that you work outside of the standard hours and specifically draft something for a judge to grant you non-standard hours. For many people, getting non-standard driving hours so that they can maintain their job is critical so that they can keep their household afloat. If you need non-standard hours to be able to keep your job, make sure you reach out to us so that we can get those arranged. There are 3 basic situations where you could end up with an interlock. One is because you blew a 15 or higher on a breath test. 2, it could be that you have 2 DWIs within a short period of time. Or 3, you could be under a conditional restoration and therefore have it required for anywhere from 3 to 7 years. There are very few lawyers that really deal with interlock violation hearings, but let's walk through some of the basics so that you know what you're facing. There are 2 basic reasons that people end up with an ignition interlock. It can either be that they're under an alcohol content restriction or that they are under a conditional restoration of their license. These 2 different ways that you end up under the interlock change the administrative procedures on how violations occur, and they change the appeal procedures. So it's critical to know the difference between an alcohol content restriction and a conditional restoration. If you are under an interlock requirement, there are 3 different companies that are recognized in North Carolina: Monotech, Alkalock, and SmartStart. Each company has strengths and weaknesses, so contact our office and we'll discuss whether you want to use one company over another, but ultimately you do have choices. If you get an ignition interlock notice in the mail from the DMV advising that you have violated the terms and conditions, it's critical that you respond to that within 10 days. If you have any type of ignition interlock problems, or if you have a suspension that we've discussed earlier with civil, criminal, or administrative, reach out to our firm and we will work to get you driving as quickly as possible.